we're on. Okay, anybody else?
Hello? Darla? Thank you, Bonnie.
All right. Oh, we got more people joining. That's fantastic. I'm really glad to see that. Okay, anybody else want to introduce themselves? If not, we'll go ahead and kind of get stuff started. I'm going to go ahead and start sharing my screen here. And we'll get this thing kicked off because we got limited time and I want to make sure Eric has plenty of time to cover a lot of information. So again, my name's Eric Kingston, Eric with a K, and I work with Idaho Housing and Finance Association and run their Housing Information Referral Center, Housing Hotline, and then also kind of take point on a lot of their fair housing issues. Let's see, I'm going to go ahead and just kind of go through some slides here, and I've got a couple other introductions to make along the way. So again, if you're looking for transitional housing and shelter provider information, you are in the right place. I'm going to go ahead and click through that. I want to thank the Department of Housing and Urban Development for their support for our work this year. Eric Stephen, of course, the presenter today, for his time and expertise. Special thanks to Christina Carlos in the Marketing Communications Department for helping with registration and getting certificates out. And I'll just kind of go through there. There's the acknowledgement and disclaimer from HUD. This tells you that Eric is responsible for all the legal interpretation of the information here, and HUD is not. And then we will be recording. We are recording this for future reference. So we'll be posting this on our YouTube channel, and that link will be available on our webpage. And I'll make sure and post some links to the pages that you'll want to check in on. Okay, so if everybody wants to mute themselves after the introductions, that'll help us out. And type questions, comments, or resources in the chat, and we will do our best to get to everything. Again, Eric Stephen, he is with Eric Stephen Law. He is Eric Stephen Law out of Spokane, and he's worked for many, many years in Idaho. And for those of you who have worked in the past with David Penny at Kosho Humphreys, he's now with Tomlinson Associates, and he's been helping do some of our fair housing presentations this year, but is not seeing private clients. So Eric is available as well as a couple other attorneys that are listed on the Fair Housing Forum resource page. And then I'm going to turn this over to Eric, and this is going to be a little bit different presentation. He's going to go through mostly some case law that is relevant to transitional housing providers and emergency services or emergency shelter providers. And I'm going to turn this over to him.
Thank you very much, Eric. My name is Eric Stephen. I'm an attorney in Spokane, Washington. I practice in every county east of the Cascade Mountains in Washington and northern Idaho. I represent landlords as the focus of my practice. Particularly, I represent subsidized housing providers and manufactured housing communities. I write policy, I perform evictions, I help landlords with lease enforcement, and I defend landlords charged with housing discrimination. Like I said, I've been doing this for 30 years. About 10 years ago, I was asked to partner with Zoanne Olson at Intermountain Fair Housing Council out of Boise and address shelter care issues at that point in time. Zoanne Olson and I worked together to create a summary of the law relative to shelters as the Fair Housing Act would apply to their activities. And I haven't really looked at shelters a whole lot since then, other than from just case-to-case situations that would arise. I do represent Catholic Charities in the Eastern Washington area, and I've represented Catholic Charities in the Yakima area in the past. So I do see some shelter care issues, not a whole lot. Today we're going to talk about how the Fair Housing Act, how the ADA can apply to shelters. I'm going to go through a bunch of cases with you. It's going to be kind of a walk down history lane, if you will, talking about how the laws developed relative to shelters with respect to the Fair Housing Act and the ADA. I'm going to talk to you about the federal definition of a dwelling and as that applies to shelters. I'm going to talk about gender segregated facilities in Canada briefly and some of the issues they've seen. I'm going to talk about legal and ethical issues facing homeless shelters. I'm going to talk about housing discrimination with persons that are LGBTQ, and then equal access, HUD's equal access to housing final rule from 2016. Then we're going to talk about the Warden Memo, which is a body of law recently released by the Biden administration. And we are going to talk about some of the consequences of not following these laws and how that's impacted you guys, shelters that is. And if we have time, we will go into our fair housing materials that are sort of generic fair housing concepts that we can cover. So the first thing we're going to do is we're going to start talking about some old cases. And I'm going to start with the United States versus Hughes Memorial Home case back from 1975. And this is an interesting case. It was a case where the defendant, Virginia Children's Home, had made dwellings unavailable to Black children. And it was Hughes Memorial Home. It was a private, non-sectarian children's home located in Virginia. The home was open to needy and dependent children. The home was founded by a individual who died, and he left a will. In his will, Mr. Hughes' will provided that the institution shall be established for the white children of Virginia and North Carolina. So the application of Robert Turner of Danville was rejected on behalf of his grandchild, who was a person of color, and they brought suit against the home. Okay, I mean, it's kind of incredible for us looking back to think that as late as 1975, discrimination on the basis of color was being sanctioned in Virginia, and that's really tough for me to swallow. I hope it would be difficult for you to swallow as well. The issue in this case was whether the home was within the scope of 42 USC 3604A, and whether that home fell into the Fair Housing Act because it's occupied as a residence. And they looked to the Webster's definition of residence. Well, first of all, they looked at the definition of a dwelling, and under USC 3602 subparen B, it says dwelling means a building, structure, or portion thereof which is occupied as or designed or intended for occupancy as a residence by one or more families, and any vacant land which is offered for sale or leased for the construction or location thereon of any building, structure, or portion thereof. And then they looked at they looked at the definition of dwelling under the Fair Housing Act, and then they looked at the definition of residence, and they had no definition of residence under the Fair Housing Act. So they looked to Webster's dictionary. And Webster's dictionary defines residence as a temporary or permanent dwelling place, abode, or habitation to which one intends to return, as distinguished from the place of temporary sojourn or transient visit. They then went on to find that the record establishes that, as the very title of this institution implies, the home is far more than a place of temporary sojourn. So they ultimately found that the home needed to conform to the Fair Housing Act. They applied a trust doctrine that allowed them to keep the trustees' intent in creating the trust, but they changed it so that it applied to all children and got rid of the children of color limitation, so that it did not only service white children in the future. That's the first case that we had that started looking at these institutions that would be considered non-traditional housing institutions as a dwelling under the Fair Housing Act. The next case we got to is Bragdon versus Abbott. And this is a case with the American Disabilities Act. And it's a little strange because it's not a housing case, but I think it comes in to what you guys do as shelter care providers. And I'm expecting that you probably have a lot of different business models in your shelter care housing portfolio. So I know there are some emergency shelters that rotate beds all the time. And I believe there are probably some shelters out there that are a little longer stay and might provide beds. And some of these cases are going to address how you're doing business and what types of business models invite application to the Fair Housing Act and what type of business models don't. I also anticipate that you as shelter care providers run into situations where you have somebody that might come into the shelter as a guest that is infected with some sort of infectious disease or possibly constitutes a direct threat to your populace. And I believe that it's important for us to go through some of the case law that applies to those situations. So when we're looking at Bragdon versus Abbott, this is a dentist, and a person with HIV came in to visit this dentist back in 1998, and he refused to treat them at he refused to treat the HIV infected patient at his standard office and wanted to treat him at the hospital. And the guest got upset about that and filed claim. And the rule in this case is the ADA is not operative and the definition not satisfied unless a person has a physical impairment or mental impairment that affects major life activity. So the ADA is not operative, and the definition of the ADA is not satisfied in the scope of coverage unless the physical or mental impairment of the individual bringing claim affects a major life function. They then got into, and one of the problems in this case was the patient was dormant, didn't have, although the person was affected by HIV, his symptomology was not manifesting itself. So the court kind of looked at all the potential impacts of HIV. And they said reproduction is a major life activity for purposes of the ADA. The complainant in this case was arguing that, that even though their HIV condition was dormant, they were still impacted by it. And so the court found that their life activity and reproduction activity was impacted by HIV. The court made a rule that physical impairment is a substantial limit on major life activity is a final element of disability definition. So whether physical impairment is a substantial limit on the major life activity is a final element of the disability definition. Evaluation of medical evidence leads the court to conclude that respondents' HIV substantially limits ability to reproduce, which is a major life activity. The ADA definition is met, even if the difficulties from impairment are not insurmountable. So the dentist was arguing that the HIV condition was not prevalent, so they weren't covered by the ADA. And even if it was prevalent, there were ways that they could work around the disability. The court wasn't going to have anything to do with it. The court rule made some findings that notwithstanding ADA protections for disability, the doctor could refuse treatment if the patient's infectious condition posed a direct threat to health or safety of others that cannot be eliminated by modification of policies, practices, or procedures, or by the provision of auxiliary aids. The court had some dicta saying that existence or non-existence of a significant risk must be determined from the standpoint of the person who refuses the treatment or accommodation, and the risk assessment must be based on medical or other objective evidence. In this case, the dentist was pointing to concerns about treating this HIV-infected person that weren't really well-founded in medical journals or treatise. And the court said views from public health authorities are of special weight and of authority. A healthcare professional who disagrees with the prevailing medical consensus may refute the prevailing views by citing credible scientific basis for deviating from the accepted norm. But in this case, they found that the complainant, the patient who was refused services, was citing good medical evidence, and that the doctor was not. He was basing his overly cautious procedures based on speculation and scientific data that was not tested or supported. The dissent took issue with the notion of individualized assessment and the petitioner's asymptomatic HIV status. And it's just an interesting case with respect to direct threat. And I imagine you guys have people that come into your institutions, your shelter institutions from time to time that are sick or unhealthy or might pose a threat to others. And I think you got to go back to that rule, which is the petitioner, the doctor, or the treatment facility in this case could refuse treatment if the guest's infectious condition posed a direct threat to health or safety of others. But you have to take into account the duty on your side to try and eliminate, through modification of policies, practices, or procedures, or through the provision of auxiliary aids, a way to minimize that direct threat. And it's incumbent upon you as the shelter care provider to be creative and see, are there workarounds here? And even though you have somebody that might constitute a direct threat, you still have a duty to try to mitigate that behavior and that direct threat before you exclude. So that's the rule and the information that I want you to glean out of that case. The next case we're going to talk about is Lakeside Resort Enterprises, LP versus Board of Supers of Palmyra, DP. And this was an interesting case. It's whether we consider whether a proposed drug and alcohol treatment facility under the facts of this case qualifies as a dwelling under the Fair Housing Act. Due to funding restrictions, the residents of the facility would stay there slightly more than 2 weeks on average. The facility is intended for longer stays, and many guests stay longer than 2 weeks while they're there, but residents would treat the facility as a home. So in the Lakeside case, once again, the issue was whether the proposed drug and alcohol treatment facility under the facts qualifies as a dwelling under the FHA. A dwelling under the FHA is any dwelling structure or portion thereof which is occupied or occupied as or designed or intended for occupancy as a residence by one or more families, or any vacant land which is offered for sale or lease for the construction or location thereon of such building, structure, or portion thereof. In the Lakeside case, recovering alcoholics and drug addicts are handicapped. The court found so that as long as they are not currently using illegal drugs, they do meet the disability definition under the Fair Housing Act. They found that residence is a temporary or permanent dwelling place, abode, or habitation to which one intends to return, as distinguished from a place of temporary sojourn or transient visit. So that's going to be a common theme for you shelter care providers as to whether or not the guests intend to return and whether they treat it as a home. It says the Fair Housing Act would presumably cover facilities whose occupants remain for more than a brief period of time and who view their rooms as a residence to return to. And then the Lakeside Court, and this is the Third Circuit, folks. So we were dealing with this in trying to figure out what state this was in. I haven't seen it. The court in this case looked at a bunch of prior cases, and what they said was that we've looked at other cases under the Fair Housing Act and what constitutes a dwelling and what doesn't constitute a dwelling. And they said, well, we found that motels are not a dwelling. A children's home with a 4-year average stay is a dwelling. Hospice for terminally ill AIDS patients is a dwelling, and a nursing home is a dwelling. Then, quoting the Columbus County case, they cited a 2-factor test. And they said, to determine whether a specific facility constitutes a dwelling under the Fair Housing Act, we'll consider whether the facility is intended or designed for occupants who intend to remain in the facility for any significant period of time, and whether the second question is whether those occupants would view the facility as a place to return to during that period. The short funding limited average stay is not dispositive on these issues. The court found in this Lakeside case that the facility is intended to house persons for a significant period of time, with the occupants who view the facility as their home during that time, and it's a dwelling under the Fair Housing Act. One of the things that goes on in a lot of these cases is they look at the guest and whether the guest is returning to the same bed, whether the guest is required or provided a preference to return to the same bed, whether the guest gets to decorate the area around their bed. And those factors are facts that weigh into these considerations and determinations as to whether or not a facility is considered a dwelling for application of the Fair Housing Act. So if you don't want to be under the Fair Housing Act, then you need to make sure guests don't return to the same bed night after night. You need to make sure that they don't decorate, hang pictures, or otherwise claim an area to be theirs, and that you don't provide any preference to any area. The next case that we looked at is the Jenkins case. This is a 2009 case from New York. And this was a shelter care facility. And this shelter care facility had two areas. They had an area for guests that had mental health issues, and then they had an area for the general populace. And in this case, Jenkins, the guest, was diagnosed with schizophrenia and was placed in a mental health chemical dependency abuse program instead of being placed with the general populace. The court, in looking at this, found that Jenkins had no claim for deprivation of a property right without due process because he has no property right to placement in a particular type of shelter under New York law. The court found that the right to shelter is not boundless, is not a boundless entitlement, and may be subject to eligibility requirements and other limitations. Homeless persons don't have the right to choose their own temporary placements in a true shelter that is exempt from the Fair Housing Act due to not being a dwelling. But then the court shifted gears a little bit, and they said that unjustified placement or retention of persons in institutions severely limits their exposure to the outside community and constitutes a form of disability discrimination under the ADA, Title II. The ADA does not require changes that would fundamentally alter the nature of services, programs, or activities. And similarly, the Fair Housing Act does not require landlords to make changes or accommodations that would fundamentally alter the nature of their program or activities. The ADA does not justify the wholesale elimination of institutionalization in favor of community-based treatment, was a finding. The ADA only prevents discrimination against those individuals with a disability who are otherwise qualified to receive the benefit. And then the court found that the state may rely upon the reasonable assessments of its own professionals in determining whether an individual meets the eligibility requirements for a specific program. And the court should normally defer to the reasonable medical judgments of these public health officials. So in this Jenkins case, the homeless shelter was deferring to the medical diagnosis that Jenkins was schizophrenic. Jenkins was taking the position that the medical diagnosis was inaccurate and wanted to proffer his own diagnosis. And the court was saying that the shelter could rely on their medical professionals' diagnosis in restricting Jenkins to the disabled section, mental health disability section of their shelter facility. The court then found that under Title II of the ADA, states are required to provide the least restrictive mental health placement to persons with disabilities when the state's treatment professionals determine that such placement is appropriate, and the affected persons do not oppose treatment and the placement can be reasonably accommodated, taking into account the resources available to the state and the needs of others with disabilities. The court then shifted gears again and looked at whether the homeless shelter qualifies as a residence and is therefore a dwelling under the FHA. The court looked at the Ninth Circuit, which has applied the FHA to homeless shelters. And for your edification, guys, you're in the Ninth Circuit in Idaho. At the pleading stage, the subject homeless shelter could fall within the fair housing definition because Jenkins intends to stay at the shelter as long as he can and has no other home to go to. Jenkins, and then the court looked at it and said, well, Jenkins doesn't pay rent and he's not a renter. And then they said no payment of rent is necessary because the Fair Housing Act makes it illegal to otherwise make unavailable or deny dwelling to any person. However, the Ninth Circuit has recognized that the otherwise make available or unavailable or deny a dwelling under the Fair Housing Act is limited to buyers and renters. So ultimately, they didn't find the application of the Fair Housing Act in this situation. They passed on that, but I think it's an interesting case, and it's interesting going back to this this notion that if you are restricting somebody due to a disability condition, especially a mental health condition, then you need to limit that restriction or that placement as necessary to protect the patient and the other people around you or the other guests. So you want to use the least restrictive placement possible. And if there's a question, then you probably want to reach out to a medical professional and get their weigh in on this. It's going to be interesting. In your typical emergency shelters, I don't think you're going to be able to ask about the nature, severity of disabilities. That's typically taboo. I suppose if you got wind of their disability condition or it was obvious or apparent, you might be able to start implementing restrictions, but your restrictions need to be the least restrictive placement available. So tough read for you guys. Next case is the Intermountain Fair Housing Council versus Boise Rescue Mission. This is one of two cases. Interesting situation. The court found that Boise Rescue Mission is a religious nonprofit corporation that operates emergency service programs, including a homeless shelter. Rescue Mission offers a variety of religious services to shelter guests. Rescue Mission does not charge fees to shelter guests and does not generate revenue. No guest has a private room, and there is no advantage or right given to returning guests over new guests. Shelter guests may not receive most phone calls or mail. Guests may not hang pictures. Guests are limited to in coming and going and may not have visitors for the most part. Guests must use program pajamas. Guests are allegedly required to participate in religious activities to reside at or eat at the shelter. And individuals who do not participate in religious services do not receive the same level of services as those who do participate in services. So if you participated in the religious services, you'd be the first to pick a bed and you might be the first to eat. And if you didn't participate in the religious services, you would be the last to pick a bed and you would be fed after the other populace is fed, and you may not get the same food if they ran out. The Ninth Circuit has not squarely addressed whether shelters are within the definition of the Fair Housing Act. The dwelling does not include a city, so dwelling under the Fair Housing Act does not include a city jail, lodging for transient guests such as hotel or bed and breakfast. The court found that dwelling does cover summer bungalows, cabins for migrant workers, nursing homes, drug and alcohol treatment facilities, and group homes for children. The court distinguishes this case from the Woods case in that the stay period at Wood was for much longer, and in this matter, the stay of a guest at Boise Rescue Mission is only a temporary sojourn or a transient visit and not a dwelling unit under the Fair Housing Act. And this is, again, one of those cases where the shelter didn't allow the people to keep a specific bed, didn't give a preference to returning to a bed, didn't allow them to decorate around the bed, and tried to dispel any notion that the tenant or that the guest could treat the bed as a permanent home. The court went on and found that the Fair Housing Act provides an exemption for religious organizations from fair housing liability for limiting sale or rental of occupancy of a dwelling if the operator can demonstrate that it is a religious organization or is operated and supervised or controlled or in conjunction with a religious organization, that it operates the homeless shelter and discipleship program for other than a commercial purpose, and it limits occupancy to the shelter and residence to persons of the same religion, unless the membership in such religion is restricted on account of race, color, or national origin. So that's the test for the religious affiliation exemption. And it says the Fair Housing Act does not apply because rescue mission does not limit shelter occupancy based on religion. There was a conflict in the facts here. Boise Rescue Mission acted like it wasn't giving a preference, and the complainant was saying they were. I tend to think Boise Rescue Mission was. I think Eric Kingston, who was knowledgeable of the facts, would tell you that his understanding of the facts was that Boise Rescue Mission was offering a preference to the people participating in religious services. The court goes on and says rescue missions activities are protected by the First Amendment to the Constitution and the freedom of religion. And then they started talking about the Freedom of Restoration Act, Religious Freedom Restoration Act, the RFRA. And they said that this RFRA, Religious Freedom Restoration Act, provides that government shall not substantially burden a person's exercise of religion, even if the burden results from a rule of general applicability, unless the government demonstrates that the application of the burden to the person is in furtherance of a compelling governmental interest and is the least restrictive means of furthering that compelling interest. The court then found that the Ninth Circuit has not addressed the application of the FRCA to private parties as a defense to enforcement of the federal statute. They'd looked at it in a different context. The Ninth Circuit has held that because an employer was a private party and not a governmental actor, it could not be found liable for violating the RFRA. And the court declares that the court declines to determine if the RFRA can be invoked as a defense, as rescue missions, homeless shelter activities are protected by the free exercise clause of the First Amendment. And then they get back into the free exercise clause of the First Amendment, and they say it provides that Congress shall make no law prohibiting the free exercise of religion. A statute burdens the free exercise of religion if it puts a substantial pressure on an adherent to modify behavior, tend to violate his beliefs. The right to free exercise from religion unquestionably encompasses the right to preach, postulate, and perform other similar religious functions. When determining whether the application of the statute would violate free exercise clause, the court must weigh the following factors: the magnitude of the statute's impact on the exercise of religious belief, the existence of a compelling governmental interest justifying the burden imposed upon the exercise of religious belief, and the extent to which the recognition of an exemption from the statute would impede the objectives sought to be advanced by the government. And so in this case, one of the things that goes on is they looked at Boise Rescue Mission's charter documents and their intent. And I thought that the Boise Rescue Mission charter documents were really well drafted for the religious exemption purpose. And the court found the application of the Fair Housing Act would have a tremendous negative impact on the Rescue Mission's exercise of religious beliefs. Rescue Mission is a Christian-based religious organization formed for the purposes of providing for the worship of God, the treatment and preaching of the Word of God, and winning of people to personal faith in the Lord and spiritual improvement of mankind. So that was their their charter, and I'll read it again to you because I think, like I said, I think this is very artfully drafted. Rescue Mission is a Christian-based religious organization formed for the purposes of providing for the worship of God, the teaching and preaching of the Word of God, and the winning of people to personal faith in the Lord and spiritual improvement of mankind. Essentially, their charter was saying that we're providing these drug and alcohol services through faith, and that you had to accept faith in God and Christianity to participate. The court then found that Rescue Mission operates the program to enable residents to free themselves from addictions by his or her personal faith in Christ. There was no compelling government interest to justify the burden imposed on Rescue Mission's exercise of religious belief, and they didn't find a violation in this case. But once again, this is an interesting case because they really wrapped in the treatment facility to furthering the religious beliefs. So you couldn't get treatment unless you accepted the religious beliefs. This was a two-person case in that when this case was kicked off, there were two plaintiffs. One plaintiff was in the drug and alcohol treatment portion, and the other person was in the shelter portion. And one of the people in the drug and alcohol treatment portions was had a criminal conviction, and they were being removed from incarceration as long as they were in treatment. And the Boise Rescue Mission kicked them out of treatment because the person indicated they were not Christian and didn't accept the Christian beliefs. And when they got kicked out of the Boise Rescue Mission program, they were then back into custody and incarceration. So pretty interesting case. And there's another case that follows up, but I want to call on Eric Kingston right now because I think he has some stuff to add on this one.
So yeah, Eric, boy, that's a lot of a lot of legal stuff. So I guess the only thing I would add is, Eric mentioned that I, basically because I run the housing hotline over the years, when I've referred folks looking for shelter to the Rescue Mission, I've had a few people that have been previous residents there, been previously staying there, who basically said, no thanks, I don't want to have to wait in line, wait till the end after everybody has been fed to go in. And they didn't want to be kind of, as they thought, as they represented it, forced to engage in religious practice. But the other thing I think that's interesting is the Rescue Mission basically said, we're not going to take any public funds. So, they're using private money for all of their operating expenses. And my understanding is that's sort of an important distinction. So anyway, but there's a lot of detail there. I guess, one thing I would say, Eric, is, for most of the folks today in the audience who are not attorneys, probably like, what are some of the factors that they need to consider when making a decision, when they're presented with somebody maybe with an infectious disease. Today that might be COVID, it might be something else. How do they deal with someone who poses a direct threat in maybe other terms? And what kind of practical steps do they take to maintain compliance and, kind of avoid a problem, with complaint. So those would be the things I had. I also want to make sure that everybody feels free to put in a couple questions in the chat so we can try and get to those before we run out of time. So is that?
I think those are good points. I look at the Boise Rescue Mission case as really well-grounded in, and I think that the Boise Rescue case was really, really impacted by their definition in their charter of their purpose. And like I said before, I think they did a good job in saying, hey, we're providing treatment, but it's through faith in God and Christianity, right, which is kind of an interesting notion. It's not something I would have probably thought of on my own. when we get back to the direct threat, I think we have to digress through those cases we talked about earlier, and we got to get back to the Bragdon Abbott case, which is the dentistry case, and under the ADA that also kind of, I think, expands into the Fair Housing Act, which is, I think you have to look at the least restrictive means for dealing with this person that constitutes an alleged direct threat. I think you have to see what are your resources available that would potentially allow you to provide services to this person that would not constitute a direct threat to others. And I think you have to be creative, and you can't just say somebody constitutes a direct threat without trying to figure out all the different ways you could potentially minimize or eliminate that threat to the other populace. And it's going to be difficult, and it's going to be factually driven on a case-by-case basis. So it's tough, and I think the other tool is start off by if you can, and if it meets with your business model, if you're truly an emergency shelter, then like I said, and I'll digress, don't let people choose their beds. Don't let people decorate their beds. Don't give a preference for choice of beds. And don't let people act like it's a home. Most shelters that I'm familiar with, the emergency shelters, make everybody leave at some point in the morning or early afternoon, make everybody come back in and check in. And I think if you're gonna maintain your position as a shelter that's not covered by the Fair Housing Act, then you can't be a dwelling. You've got to be a place of temporary sojourn where nobody is too comfortable declaring this to be their house or their domicile. Even if they do tend to come back every day, you can't let them get too comfortable with one specific location in the shelter, because that's how you're going to fall into the dwelling issue. So the next case that we have is the second Intermountain case. The first one was 2009. The second one was 2010. The two plaintiffs in this case, as I alluded to, were Coles and Chin. And Coles participated in a drug treatment program and was asked if she was a Christian. She confirmed she was not a Christian. The director contacted Coles' probation officer and advised Coles could not complete the treatment program with Boise Rescue Mission, and Coles was sent back to jail. The other complainant in the case was Chin, and Chin was in the shelter services. Chin claimed he received inferior treatment over guests who participated in religious services. So Chin was part of the shelter services. Coles was part of the drug treatment. Coles filed a claim for sex discrimination. She was a female. She claimed that women were treated differently there, and that claim was dismissed for lack of evidentiary support. Then she filed a claim for religious discrimination, and the court found that homeless shelters are not a residence because the defendant does not permit its guests either to stay there for a significant period of time or to treat the shelter as their home. And even if the Fair Housing Act did apply, the FHA religious exemption permits the challenge practices in this case. So in that second Intermountain case, they passed on it again. I've talked to Zoanne Olson. She was there at the time at Intermountain Fair Housing Council when these cases were going on. She was pretty disappointed in the rulings of the court at those times and frustrated with that, but it is what it is, and we move on. So that's where she's at. There's another document in the materials that talks sort of about a summary of the housing shelter stuff, and it goes on and it says there's a split of jurisdictions. Some jurisdictions have used the plain meaning test, which looks to see if the shelter qualifies as a temporary or permanent dwelling place, abode, or habitation to which one intends to return, as distinguished from a place of temporary sojourn or transient visit. And then they looked at the Third Circuit, and that they used a different test. They used a two-part test that we talked about, whether the facility is intended or designed for occupants who intended to remain in the facility for a significant period of time, and whether those occupants would view the facility as a place to return to. So you can actually fall into coverage if you just have a place that is designed to be returned to. And then it talked about religious exemptions. So The summary of materials on the second page goes and starts talking about persons who pose a direct threat. Nothing in this subsection requires a dwelling to be made available to an individual whose tenancy would constitute a direct threat to the health, safety of other individuals, or whose tenancy would result in substantial physical damage to the property of others. And when you evaluate direct threat, the Supreme Court said that the existence or non-existence of a significant risk must be determined from the standpoint of the person who refuses to provide the accommodation, and the risk assessment must be based on objective evidence. So objective evidence is some real evidence above and beyond speculation or hypotheticals. So to the extent that you've got, that you're going to take action against somebody that you believe constitutes a direct threat, you need to have specific evidence that they constitute a direct threat. That's kind of scary if the person hasn't acted hostilely in the past and you don't have any real evidence of direct threat. So it might mitigate your ability to declare that. I really think we're getting closer and closer in HUD's eyes and in the law to not being able to anticipate actions. And that's really unfortunate. I don't like the notion that we have to wait for something to happen before we can take precautionary means. And that really bothers me. And I think the law is getting closer to that. We've talked about the Fair Housing Act. We've talked about dwellings. The materials at 42 USC 362 or 3602, excuse me, define dwelling. We've talked about this earlier. Dwelling means any building, structure, or portion thereof which is occupied as or designed or intended for occupancy as a residence by one or more families, and any vacant land which is offered for sale or lease or for the construction or location thereof of any such building, structure, or portion thereof, that it'd be a residence by one or more families. So even in the development stage, you can fall into the definition of a dwelling. The next document we have that we're talking about is just an article from a Canadian journal that I found that talks about gender segregated facilities. And I wanted to broach this with you because I more than anything else, I'm just trying to generate issues for you guys to think about or make sure you're thinking about these issues. My guess is you probably already are. But this article starts by saying that many everyday spaces are segregated by gender. Public washrooms, locker rooms, for example, are spaces that are for the most part, gender segregated. Spaces commonly believed to be safe, such as public washrooms, are often instead sites of violence and exclusion for people that are of transgender. These transgender people or trans people routinely experience confused looks and harassment when trying to use a washroom. And then it goes on, it says, gender segregated social services and resources meant to support people who experience poverty, violence, and discrimination are even more complicated to navigate. The difficulties of trans people face in these public spaces, such as public washrooms, are relatively minor or brief compared to those experiences they have in many homeless shelters, drug and alcohol detox facilities and rehabilitation facilities, and some crisis support centers. The article talks about, similar to shelters, detox centers and rehabilitation centers in Quebec do not have an official policy regarding how trans people are housed, and access is usually granted on a case-by-case basis. Most often, though, people are housed according to their gender marker on their government-issued ID. So I'm just raising this issue with you and reading this article to tell you that everybody else is struggling with this too, not just the United States. Canada's struggling with it, and they don't really have any great fixes as of yet. There's another article in the materials from Sam Kellenberg, and this was from December of 2019. And it was an article that I read called Legal and Ethical Issues Facing Homeless Shelters. And it said homeless shelters and many nonprofit organizations face a number of legal and ethical issues which can divert valuable resources away from treating homelessness. In some cases, these issues can result in more damage to the homeless populations. Homeless shelter, despite these problems, homeless shelters still provide necessary resources to needy individuals, and many homeless shelters actively support a number of other programs to assist homeless individuals. And then the article goes on, it looks at different types of problems that youth shelter folks are experiencing. And the first one they talk about is family homelessness. It says, as of 2010, it is becoming increasingly more common in the United States for families to experience homelessness together. One significant legal and ethical issue facing families, homeless shelters, is whether children's services should be notified of a homeless family with children. In many cases, children's services programs separate children from their families to be placed with relatives in foster care or institutional homes. There's an ongoing debate as to whether it is better for children to remain with homeless parents in a shelter or to be subjected to unfamiliar environments. So one of these new issues that you're probably running into is placing families that are homeless together, and potentially the decision on whether or not to call Child Protective Services. Another problem facing shelters is youth homelessness. And the research shows that anywhere between 5 and 7.7% of youth experience homelessness each year in the United States. Homeless shelters must make the call on whether to report such homeless youth to child service organizations. And then it raises issues about farming youth out for labor and whether these youth get caught up in sex trafficking situations. The article then talks about veteran homelessness, talks about how veterans are disproportionately overrepresented in homeless populations, and that there's a lack of government programs to help veterans adjust to civilian life after service, and that is contributing to veterans' homelessness. And the cases are found every year in which homeless shelters serving veterans have been abusing federal or state assistance to the homeless veteran population in various forms. So make sure that you guys are monitoring your veterans benefits and making sure that there's a fail-safe check system on how veteran benefits are being administered in your shelters, and be sensitive to this veteran homelessness issue. And then it has another heading here in this article talking about other legal issues. In some cases, homeless shelters don't have enough funds to hire legally required number of supervisors, attorneys, or social workers, or to upgrade facilities. Some shelter policies require applicants to fill out various waivers releasing potentially sensitive personal, legal, accounting, or health information before receiving services. So be careful in sharing information, requiring information. One of the things we're going to talk about later on is your ability to ask guests for information about their gender and that type of thing, and we'll be getting into that here shortly. But you just need to be guarded in the information you're asking from people and the information from these people with which you're sharing to other providers. The next portion of the presentation is just a very quick blurb by the HUD that talks about housing discrimination with persons identifying as LGBTQ. This document just in essence says that HUD's equal access rule requires equal access to HUD programs without regards to a person's actual or perceived sexual orientation, gender identity, or marital status. Housing providers that receive HUD funding or have HUD insured loans are subject to these rules. So you're going to have an equal access rule if you're receiving HUD funding or have HUD insured loans. And your equal access rule have to provide access to people without regard to the person's actual or perceived sexual orientation, gender identity, or marital status. A person who identifies as LGBTQ who has experienced discrimination or is about to experience discrimination by a HUD-funded or FHA-insured housing provider or lender may report it to HUD by either filing a complaint or by contacting local fair housing equal opportunity enforcement. So then after that, it gives a list of state local laws prohibiting discrimination on the basis of sexual orientation or gender identity, and lists a number of states. Idaho is not on that list, as you do not have such a law at this time. Next, we get to September 16, 2016, or September 21, 2016, the Equal Access Housing Final Rule. And I'm going to go through this final rule in part. There's a lot of sub-rules that you get from this Equal Access Rule. And this is 24 CFR Part 5. And this document gives us a number of rules. It says this rule builds on HUD's February 12th final rule entitled Equal Access to Housing in HUD Programs regardless of sexual orientation or gender identity. It says that transgender and gender nonconforming individuals should be accommodated in temporary emergency shelters and other buildings and facilities used for shelters that have physical limitations or configurations that require and that are permitted to have shared sleeping quarters or shared bathing facilities. So if you have a physical limitation in your shelter that requires shared sleeping quarters or shared bathing facilities, you are required to make reasonable accommodations. This rule amends the definition of gender identity. This rule makes a technical amendment of the definition of sexual orientation. Then it talks about the 2015 Community Planning and Development Guidance, and that was titled Appropriate Placement for Transgender Persons in Single-Sex Emergency Shelters and Other Facilities. So this is guidance that relates to single-sex emergency shelters and facilities. It says this guidance clarified that HUD expected recipients and subrecipients under these programs to base placement decisions on the gender with which the person identifies and not another person's stereotype-based complaints, taking into account health and safety concerns and giving serious consideration to the transgender or gender nonconforming person's own personal health and safety concerns. This guidance outlines best practice for providers. It says during interactions on the phone with, and this is talking about the case history and development and promulgation of this rule. And they did a bunch of studies and investigations, and they did testing with shelters. And it found that during the interactions on the phone with shelter employees, testers experienced the following. They were often referred to using the wrong gender, or shelter employees referred to using the wrong gender, or shelter employees made their statements to discredit the gender identity. Shelter employers made reference to the tester's genitalia or surgery as a requirement for appropriate housing. And shelter employees stated that other residents would be made uncomfortable or unsafe by the tester. So these are testers that are contacting the shelter and identifying as non-conforming gender or transgender. And when they did the investigation, they found that these people were referred to using the wrong sex or gender. They found shelter employees were discrediting their gender identity. And shelter employees, when they were on the phone with these non-conforming folks, non-conforming gender folks, were making comments about the person's genitalia or lack thereof, or the need for surgery, and were raising concerns about hypothetical concerns that were speculative about what other guests of the shelter would think. It says that in May of 2016, the Department of Justice and the Department of Education released guidance summarizing the legal obligations of schools regarding transgender students. The guidance specifically emphasizes that schools must treat a student's gender identity as the student's sex for purposes of Title IX in implementing regulations. In sex-segregated activities and facilities, transgender students must be allowed to participate in such activities and access with such facilities consistent with their gender identity. Guidance requires schools to provide a safe environment for all students. It requires schools to treat students consistent with their gender identity, regardless of records or identification documents indicating a different sex. So they give some deference to what the schools are doing under this May 2016 DOJ and DOE guidance. Then they make a change to the final rule regarding gender identity, and they say the definition of gender identity in the final rule makes it clear that gender identity means the gender with which the person identifies, regardless of sex assigned to that person at birth and regardless of the person's perceived gender identity. Gender identity is therefore determined regardless of the gender identified on the individual's identity documents, and this rule makes a technical amendment to the definition of sexual orientation. Sexual orientation means the emotional or physical attraction to the same or opposite sex. So what this is saying very clearly is when somebody presents to the shelter, if you're under the Fair Housing Act, you accept how they identify as gender, not what their driver's license says, not what their birth certificate says, or any other documentation says. Eric, did you want to chime in?
Well, we do have a question that's just right on for this, kind of train of thought you've got. And that is, a kind of a scenario where an individual who identifies as an opposite gender, male identifying as female, and wants to be placed in the women's housing or vice versa. However, facilities are gender-based. Can anyone provide legalities or information to this? And I think you're kind of speaking to this in a way.
That's exactly what I'm talking about. And strategies here in just a minute.
No one wants to turn anybody away. And there's, let's see, any viable solution. There's no single-sex housing in Idaho Falls or Idaho that I'm aware of. It's unclear whether it may pose a serious problem in a group living housing, that kind of thing. And I know that you've kind of mentioned the warden memo and you've been talking about this other issue, but I want to speak to that specific, like how would you as a shelter provider, operator, work on this?
Yep, that you're stealing my thunder and you're getting ahead of me because I'm going to get into those strategies right now.
Okay, and we have about 10 or 11 minutes left.
Okay, I'm going to race through this. It says, although this is not a substantive change, the change appropriately emphasizes the purpose of the rule is equal access in accordance with the individual's gender identity in community planning development programs. Generally, equal access ensures that when considerations of sex is prohibited or not relevant, individuals will not be discriminated against based on actual or perceived gender identity. Where legitimate consideration of sex or gender is appropriate, such as a facility providing temporary short-term shelter that is not covered by the Fair Housing Act, which is legally permitted to operate as a single-sex facility, the individual's own self-identified gender identity will govern. Subrecipients of assistance from community planning development include home funds, CDBG funds, HOPWA, HOPWA, ESG, and COC, as well as housing trust fund programs and rural housing stability assistance programs. The rule goes on and says, Section 5.106B addresses admission and occupancy and operating policies and procedures of recipients of those funds. All policies must be administered in a non-discriminatory manner. Policies and procedures must ensure that individuals are not subjected to intrusive questioning or asked to provide anatomical information or documentary, physical, or medical evidence of the individual's gender identity. So you cannot ask for gender identification. You have to accept what they tell you. Gender identity is distinct from sex assigned at birth and is not associated with physical anatomy and may not be indicated in medical records. And it is important that transgender or gender nonconforming persons can self-identify their gender identity orally and must be allowed to self-identify. HUD goes on and says, HUD's regulations for ESG program and implementing the guidance make it clear that temporary emergency shelters with physical limitations or configurations that require and are permitted to have shared sleeping quarters or shared bathing facilities have had and continue to have a responsibility to create a safe environment for all occupants, particularly those of special populations. Placement and accommodation of individuals shall be made in accordance with an individual's gender identity, and you are to remove language that permits an exception for this rule where a provider makes a written case-by-case basis. It says to fulfill the duty to create a safe environment for all, including transgender and gender nonconforming individuals, providers are strongly encouraged to post notice of rights to create a safe environment. So what they want you to do is they want you to post the equal access, regardless of sexual orientation and gender identity or marital status, HUD's community planning and development programs posters in your facilities at various locations. If someone raises a concern about an occupant's transgender or gender nonconforming status, then it says that staff should treat those concerns and opportunities as a chance to educate and refocus occupants. So if somebody is complaining about a transgender individual or a gender nonconforming individual, they are telling you that you, one, post these equal access posters, two, that you use that as an opportunity to indoctrinate the complaining person of the need to provide equal access to transgender individuals and gender nonconforming people. Providers should post policies and support residents and staff in addressing and resolving conflicts that could escalate in harassment. Those policies should include specific behavior that violate the standards of respectful behavior and escalate corrective action if an individual repeats the same violation of standards after educational opportunities are offered, and focus on corrective action on aggressors who violate the project rules, not on the person targeted by the harassment. Requiring a harassing occupant to stay away from the transgender individual, making changes in sleeping arrangements without limiting the freedom of the transgender individual, or pursuing other interventions. When appropriate, housing providers may consider expelling harassing residents or any staff or volunteer members who perpetuate discrimination against transgender people or gender nonconforming people. In no instance, however, should steps be taken to address the harassment or discrimination involve expulsion of the harassed occupants. So what they want you to do, HUD wants you to educate the people that are making the complaints about the transgender person, and then they want you to take action against the people that are harassing the transgender person, and the materials completely avoid any discussion where the transgender person or gender nonconforming person is the harasser. They act like that doesn't happen in any of the materials. I understand that may happen, but if it happens, you're going to have a real tough haul, because these materials completely omit reference to the transgender or gender nonconforming person being the harassing person. It says for post-admission accommodations, so after you've admitted everybody and got all the guests in there, providers must take non-discriminating steps that may be necessary to appropriately address privacy concerns raised by all residents and occupants, and as needed, update their admission, occupancy, and operating policies. If an individual, if another individual is complaining about a transgender individual or gender nonconforming individual, because of privacy concerns, staff may offer accommodations to that individual who's making the complaints, but may not require that individual to use the accommodations. If available, staff may offer that occupant a room, floor, or bed that is closer to the staff workstations or access rooms, or floors or beds set aside for residents with increased vulnerability. Relative to showers, if the institution offers a single occupant bathroom or provides certain times during the day for shared bathroom can be scheduled by any client with a request to use the private bathing facilities. If feasible, providers can ensure that toilets and shower stalls have locking doors or at a minimum curtains to allow for modesty or privacy. For shower use, providers may consider implementing a schedule for all clients if communal showers are the only available type of shower. And HUD stresses that all accommodations should be offered only to fulfill the request of individuals seeking the accommodation for themselves and should be available for clients based on a variety of factors. There shall be no isolation or segregation of non-conforming individuals. It says in no case may a provider's policy isolate or segregate transgender non-conforming occupants. Referrals out. It says that institutions should be open for the possibility that an occupant may request a referral to an alternative project for health or safety reasons, and such staff may provide a referral to occupants for clients to a hotel or motel or provide a hotel or motel voucher. Providers must document and maintain for a period of 5 years records of compliance with the requirements of this rule regarding establishing and amending policies and procedures for equal access. So, digressing back, with respect to
Eric, we have 2 minutes left.
Okay.
And then I've got a couple things I need to kind of pass along to people too. So,
okay. So the warden memo says that that these policies apply if you accept FAP, Fair Housing Assistance Payment Program benefits, or if you accept FIP, Fair Housing Initiative Program benefits. And then the last thing I wanted to share with you was that there was an article in the newspaper on April 12th where the NC2A, the National Collegiate Athletic Association Board of Governors, released a statement regarding transgender participation in sporting events, stating that championship events can only be held in locations free of discrimination. This came about after Idaho's controversial Fairness in Women's Sports Act, which bans transgender women from competing on women's sports teams. And when that act was promulgated, the NC2A reacted, and that Idaho will no longer be housing championship events because they are deemed not to be a location free of discrimination. I've been constantly telling audiences in these seminars that you need to be open to fair housing concepts, especially source of income and some other concepts that I think are going to be coming towards you guys. I see a lot of people thinking that that's not required. I think it is required, and I think you're going to see consequences from not following these laws in the near future.
Okay. Boy, that's good timing. So I just wanted to point out that a lot of this, so you've been reading from the, I believe, this latest thing you were reading from Equal Access to Housing Final Rule, is that correct?
Yeah, I think it's on the next slide.
Okay.
Oh, wait, no, back. I'm sorry, maybe I wasn't. It's 24 CFR Part 5. Okay,
just to clarify for everybody. So this presentation will be listed here at fairhousingforum.org. And let's see, so that is, that's this one right here. And what I'd like to do is offer to make sure that we put all this information together on that website. I'm going to go ahead and get into the website here just to show people where everything is. So this Fair Housing Month activities section, this has information. Well, it looks like a formatting issue here, but all of the slides that we presented today and then some will be linked here. If you need to find something, like a definition, you can always type a definition in here, like, it could be service animal, and that'll take you to sections that include the term service animals, common questions about service and support animals. And then if you want to look on this, the sort of index on the right side under resources and links, I'm going to kind of show you this and let you know. I'm going to add a heading at this level that is for transitional housing and shelter providers in this, so that we gather a lot of this information that Eric's been talking about into one place. So it's an easy spot for you to find information. And if you have information you want to share with us, please reach out to me or Christina, and I'll make sure and post that. Basically, this is just organized by themes, so you can see the kind of resources we're trying to provide on this website. And go back to the beginning here. But basically, that's a resource for everybody. And this is part of the Idaho Fair Housing Forum, which includes people who are advocates, their providers, their cities, counties, states, IHFA, realtors, and developers. It's everybody coming together to figure out like where we can do the most good and further the awareness of rights and responsibilities under the Fair Housing Act. So Eric, anything you want to wrap up with?
Just don't shoot the messenger. I represent landlords. I represent your side, not the other side. So I'm sharing this with you just to help you guys understand the potential issues that are out there. It's not that I wrote any of these laws or want to see these laws come down and be used for enforcement against any of you. I do defend housing providers, including shelters that are charged with housing discrimination. That's what I do. I also help people write policy. So I appreciate the opportunity to address you folks today. I understand this is a challenge for you, and I'm sorry if I've scared any of you or created apprehension. That was not my purpose. But I think this is not ignorance is bliss. This is a situation where you need to be smart, you need to be learning and open. And all of us, we all need to be open-minded. We all need to be inclusive. And we all need to recognize the ways that we violate these laws by being too narrow in the scope of our acceptance. So it's tough, but we have to adapt. And if we don't adapt, we will probably become extinct. So change your ways.
Sounds good. And then I just want to also make a shout out. Christina's put together a really nice order form so you can request these print materials. And that is posters, wall posters that are kind of a tabloid sized poster. This is it here. And then we have bookmarks that can be, kind of affixed to that poster. And then kind of some Z cards, they're called. And those kind of fold out into a big roadmap style thing. But posting stuff like that and other materials from HUD is one way that you can kind of demonstrate good faith efforts to promote awareness of fair housing and let people know what their rights are. So those are free to you. You can request any of those that you want. And then we do have our information, on the videos. We have bilingual videos that address several different aspects of fair housing law, and you can check those out as well and share those. We encourage you to follow us on Facebook and Twitter, things like that. We'll try and keep things relevant to what you're dealing with. And thanks to folks who are hanging in there. Any last questions from the audience? Okay. All right. Well, Eric, thank you very much for kind of doing the research and finding those relevant documents and like the Warden memo. I know that one was based on I think it was Bostock, an employment law decision by the Supreme Court last year, that basically said gender applies to gender identity and sexual orientation. And HUD's Warden memo basically just says it goes for housing too. So, all right. Thanks, everybody. Have a great spring.